on representing children from Central America, leveraging international law to strengthen gang-based asylum claims. I'm going to start just by introducing our speakers on today's webinar. My name is Colleen Cogill, and I'm a legal fellow with UNHCR. I'm here on a 2-year fellowship project aimed at enhancing the capacity of legal representation in the U.S. through organizing webinars and trainings that help explain how to use international law and UNHCR's position to strengthen asylum claims. Next is my colleague, Nicole Boehner. Nicole is a Senior Protection Associate here at UNHCR in the U.S. Protection Unit. Her work is largely focused on child protection, which she'll discuss in more detail in just a moment. Prior to joining UNHCR, Nicole worked as an attorney with the Pennsylvania Asylee Outreach Project at HIAS. Our next guest is Jennifer Nagda. Jennifer is the Policy Director for the Young Center for Immigrant Children's Rights, where her work focuses on developing a best interest of the child standard for unaccompanied immigrant children. Jennifer has worked at the Young Center since 2008. She is also a lecturer in law at the University of Pennsylvania Law School's Interdisciplinary Child Advocacy Clinic. And last but not least, I have Wendy Wailigala is joining us from Kids in Need of Defense. Wendy is the Deputy Director for Legal Technical Assistance at KIND. She joined KIND in November 2008 as a supervising attorney for pro bono programs, serving first in Newark, New Jersey before joining the New York office in March 2011. And just to say at the outset that we're recording the presentation and we'll make it available on our website along with the PowerPoint slides after today's presentation. So in today's webinar, we're going to cover the following topics. A discussion of UNHCR's work on child protection and international guidance on child asylum claims, best interest determinations as an example of international standards in practice, and current issues and strategies for representing children from Central America in claims arising from gang violence. At the end of the presentation, we'll go through a hypothetical case example talking about how to approach the claim and how to use international law to strengthen arguments. We'll also be taking questions at the end of the presentation, so please wait till the end to ask any questions. And I'm now going to hand it over to my colleague Nicole to talk about UNHCR's work on child protection.
All right, good afternoon, everyone. Thank you for joining us. We're excited to be able to present this information. So regarding UNHCR's work in the United States, really over the past 5 years, a lot of our attention has been focused on the front end of children's experience in the U.S. So really looking at border, children's access to the territory, and therefore to asylum procedures. And so we've done a couple of different monitoring exercises, which is a typical activity that UNHCR engages in. And so looking back to 2012, 2013, we were down on the U.S. southern border, looking at CBP's screening of unaccompanied children under the TVPRA. And then more recently, we turned our attention to detention of children in the U.S. and so conducted a monitoring this past year of ORR's program to provide care and custody to children. So always with our monitoring work, really the important part is our follow-up, which is we engage in confidential reporting on our findings and recommendations to the U.S. government. And so then, commence a lengthy process often of back and forth advocacy with the U.S. government regarding our recommendations. Typically, a lot of our work tends to be a little bit behind the scenes, but in the past few years we have done some public reporting, which I hope everybody is familiar with our report called Children on the Run, which we produced and released back in 2014. And so that was an examination of the causes for unaccompanied children to be leaving home and coming to the U.S. I'll talk about that just a tad more on the next slide. And then while not focused on unaccompanied children, we followed up the Children on the Run report with another report, Women on the Run, which we released in 2015. And our findings there really supported what we had seen in Children on the Run in terms of root causes causing not only unaccompanied children, but accompanied children and parents, well, mothers, to flee for the U.S. And so, as has everyone, we've been engaged in the long battle to adjust the narrative about why children and families are leaving the Northern Triangle of Central America to reflect that there's a significant refugee component to the flow. And so a lot of follow-up work to our reports to make that visible. We also engage in some training efforts to promote child-sensitive adjudication. And so we regularly participate in RAYO's training for new officers, and upcoming we'll be doing a session with immigration judges. And then we also engage in strategic litigation efforts. We haven't engaged on the child protection issue a ton, but most recently we did submit an amicus brief in the Flores case. And then before that, we have to go back to 2010 to Mejia Romero versus Holder. In that case, we also submitted an amicus brief. So a couple examples. I'm sort of shocked at how far back 2010 already seems. And so I wanted to make a couple quick points about the Children on the Run report, which we interviewed over 400 children from Northern Triangle of Central America and also Mexico. And it was really just pure research to find out from them directly what were their reasons for leaving home. And so, very broad strokes, we had identified that at least 58% of the children that we interviewed raised potential international protection needs. And so even though, our interviews took place in 2013 and that's already starting to feel a little bit outdated, I want to note that even at that time, that was a fairly conservative figure that we put forward from UNHCR's perspective. We didn't even include in that calculation children who are deprived of socioeconomic rights, which for us might constitute persecution, but in light of the U.S. Environment, we didn't even include that in our figure. And based on continuing escalation of harm in the region, I would confidently say that our 58% is likely much higher now. With that, I'll turn it back to Colleen.
All right, so now I'm going to talk about international law and its relevance in U.S. courts with a specific focus on child asylum claims. So to lay the framework for why international law is relevant in the U.S., U.S. obligations under international refugee law stem from the 1951 Convention relating to the status of refugees and its 1967 protocol. The U.S. acceded to the 1967 protocol in 1968. The protocol binds parties to comply with the substantive provisions of the 1951 Convention. So by acceding to the protocol, the U.S. is also bound by the 1951 Convention. By acceding to the protocol, the U.S. has committed to comply with its provisions and provide effective protection to refugees. This forms the basis of the U.S.'s obligation to comply with international refugee law. And in addition to the protocol, the U.S. also made clear its intention to comply with international refugee law through domestic law. The 1980 Refugee Act was implemented with the express intent of bringing the U.S. into compliance with the 1967 protocol, which the Supreme Court recognized in the case Cardozo-Fonseca. The Refugee Act should therefore be interpreted and implemented in a manner consistent with the protocol in the Convention. So to assist with proper interpretation and implementation of the Convention and the Protocol, UNHCR has created extensive guidance for states and adjudicators. This includes the Handbook on Procedures and Criteria for Determining Refugee Status, UNHCR's Guidelines on International Protection, UNHCR's Eligibility Guidelines, and UNHCR reports. All of these resources were created to assist lawyers and adjudicators with proper interpretation of the refugee definition. This slide also shows how U.S. courts have used UNHCR guidance. Courts have looked to UNHCR to interpret specific legal questions, such as what constitutes persecution or how to define the term membership in a particular social group. Courts have also looked to UNHCR reports in examining conditions in the asylum seeker's country of origin. UNHCR's reports can and should be submitted with an asylum claim to provide the adjudicator with background information and context about the human rights and refugee protection situation in the applicant's country of origin. For example, UNHCR's report that Nicole just mentioned, Children on the Run, could be submitted with a claim from Central America to demonstrate the conditions children are fleeing in the Northern Triangle. Focusing on resources relevant to children's asylum claims, in 2009, UNHCR issued the Guidelines on Child Asylum Claims in response to the growing number of children seeking refugee protection. The Guidelines on Child Asylum Claims offer substantive and procedural guidance on carrying out refugee status determinations in a child-sensitive manner. In terms of procedural safeguards that should be implemented in children's cases, international standards require that when the asylum applicant is a child, the refugee definition must be interpreted in a child-sensitive manner to ensure protection is not denied because of a failure to take into account the child's unique experiences of persecution or to properly evaluate the child's account of events. Factors such as the child's age and vulnerability, stage of development, and knowledge or memory of conditions in the country of origin must be considered. The guidelines can therefore be used to explain why certain harms may rise to the level of persecution in a child's case, even if those same harms wouldn't give rise to persecution in an adult claim. The guidelines can also be used to support the view that the presentation of the asylum claim must be assessed from the perspective of the child, including consideration of the fact that children cannot be expected to provide adult-like accounts and may have difficulty articulating their fears. In regards to the substance of children's asylum claims, the guidelines discuss how children may have independent claims to refugee status, separate from a parent or relative, and they also discuss child-specific forms of persecution that may be relevant in children's claims, such as underage recruitment, child trafficking, female genital mutilation, family and domestic violence, and forced labor. Lastly, I've listed a few more resources that may be relevant in preparing an asylum claim for a child. The first is UNHCR's report, Children on the Run, which Nicole discussed, and that report can be used as evidence of country conditions in the asylum seeker's country of origin. The second is UNHCR's guidance note on refugee claims relating to victims of organized gangs, which we refer to as the UNHCR Gang Guidance Note. And that note provides legal guidance on assessing claims caused by or associated with organized gangs. Next is UNHCR's recently issued eligibility guidelines for El Salvador and Honduras. These guidelines provide legal interpretations to assist decision makers and private practitioners in assessing the international protection needs of asylum seekers. The El Salvador and Honduras guidelines go through certain risk profiles of individuals who may qualify for protection. And lastly, I pulled out a few amicus briefs UNHCR has submitted that touch on issues affecting children, which Nicole also talked about. UNHCR's amicus brief in Flores explains that international law prohibition against arbitrary detention applies with special force to children who, in principle, should never be detained. And UNHCR's amicus brief in Mejia Romero, which goes through application of a child-sensitive approach to the refugee definition. And I'm now going to hand it over to Jennifer to talk about child advocacy and best interests of the child.
Terrific, Colleen. Thank you so much. Again, my name's Jennifer, and I'm with the Young Center for Immigrant Children's Rights, and I'm very privileged to be able to be a part of this conversation today. I think the Young Center sits in a unique position in immigration proceedings. We've had whether it's a privilege or a luxury of developing both a program and guidance that melds international law with what typically happens in domestic courts here in the United States to at least on the cases that we're appointed to, ensure the consideration of the best interests of unaccompanied children who are placed into adversarial U.S. immigration proceedings. Our program was launched in 2004 as a pilot for particularly vulnerable children who are in government custody. That would be ORR, or Office of Refugee Resettlement custody. That was back at a time when there were maybe 5,000 to 6,000 children per year who were being apprehended and identified as unaccompanied. But at that time, and for many years prior, there had been recognition that there was a gap in the system for immigrant children here in the United States, in that there's simply no explicit mandate in the immigration statute for decision makers to consider a child's best interest in every single decision, and no equivalent of what would be a best interest guardian ad litem in state court proceedings to identify and advocate for the child's best interests. So that's where we come in, and given that, and given the fact that that mandate still does not exist, and I apologize, Colleen, I am, of course, trying to move the slides forward, but perhaps I'll just ask you to advance the slides if that works for you. There we go. So what we are doing is working with individual children to identify their wishes, to gather facts about their cases, and to understand what it is that their parents wish and other close family members, and then apply best interest principles from other fora, including international law and international guidance, to make recommendations. And we submit those recommendations both to custodial agencies such as ORR on issues of placement and transfer and release, and of course what we'll talk about today, decisions that we submit to adjudicators here in the United States at the Executive Office for Immigration Reviews, Immigration Courts, and USCIS asylum officers on issues of permanency and whether or not a child can be safely repatriated. Colleen, if you could advance the slide. What I wanted to do was talk about how we make these recommendations in the absence of this mandate. And I would stress that the absence of a mandate does not mean that best interest cannot be considered. It simply means that there is no statutory obligation for everyone to consider best interest in every decision about a child, but nothing prohibits them from doing so. And we have generally, at least over time, had a very positive reception to our effort to submit best interest recommendations. That became a lot easier in 2008 when the Trafficking Victims Protection Reauthorization Act gave the Office of Refugee Resettlement, and specifically the Secretary of Health and Human Services, the ability to appoint independent child advocates for child trafficking victims and other vulnerable unaccompanied children. The very short statutory provision, it's just one paragraph and a few sentences, went a long way in providing some authority for the work that we were doing. Other sources that we turn to, as I mentioned before, are domestic child welfare law. If a child was in state proceedings or state custody, how would that state determine what was in the child's best interest when they had been separated from a parent? And then what we'll focus on today in the next 10 minutes or so is international law and guidance that very closely track, in some cases we're predecessors to, in other cases reflect what exists in domestic child welfare law to make arguments on behalf of children's best interests. Colleen, you can go ahead to the next slide, which shows that lovely paragraph that I referenced just a moment ago. This is the paragraph authorizing the appointment of child advocates in the 2008 TVPRA. I want to highlight just a couple of key features, and I see highlighted it in red on this screen. I think the independence of the child advocates who are making these best interest recommendations is significant, and by independence I'm referring to the fact that we don't play any other role in the system. A lot of the child advocates at the Young Center are by profession immigration attorneys. We have served as immigration attorneys in the past. We do not do that in our capacity at the Young Center, nor do we run other programs where we might provide services or receive contracts to provide services for kids. So when we make our recommendation, we can do so knowing that it won't in any way hinder our ability to serve other kids or bring some kind of benefit to the program. And I think that has helped with the acceptance of some of our recommendations. We'll talk a little bit about what it means to advocate for the best interests in this system, but I did want for just a second to highlight this term vulnerable. We have spent a lot of time over the last 12 to 13 years trying to determine who are the most vulnerable children, because there are not child advocates for every unaccompanied child in federal custody. We serve a minority of kids who come into care, and with limited resources, we've tried to identify where can we play the greatest role. And in general, we tend to work on cases involving toddlers and infants, kids who are simply too young to tell their story or to guide their attorney's representation if they have an attorney. Other vulnerable children, they're all vulnerable. I just want to be very clear about that. But particularly vulnerable include other children who are unable to advise, counsel, perhaps due to mental illness or trauma that has gone unaddressed or untreated. There are children who request action that threaten their safety, for example, returning to home country when they have presented a strong claim for asylum, often as a result of detention fatigue. Other highly vulnerable kids include pregnant and parenting teens, children who risk permanent separation from a parent against their will, and then those children who have not yet been identified as having a form of relief, but who express a terrible fear of returning, an honest fear of returning, and who are in immigration proceedings. And so those children, too, are often deemed to be particularly vulnerable. Okay, Colleen, you can jump ahead to the next slide. So I wanted to walk through just a few examples of the sources of authority that we do rely on when making these recommendations about what's in a child's best interest and how we come to those conclusions, because this international guidance, it has been extremely helpful in ensuring an integrity in our own decision-making process, but in also helping to persuade decision makers of sort of the universality of these principles and their applicability to the children standing in front of them, whether sitting in an asylum interview or appearing in defensive proceedings in immigration court. Before I run through these very quickly, I wanted to stress that when we rely on these at the Young Center, the convention, committee guidance, UNHCR guidelines, we are not using these resources to make the claim that a child is eligible for a benefit such as asylum, or eligible for asylum or for benefits like T or U status. That is very much the role of the child's attorney, and I think there is tremendously useful information in these as well for the child's attorney. But our role is about making recommendations as to the child's safety and well-being. So when we are making those when a child is in the adjudicatory phase of their case, when they're applying for asylum or trying to avoid removal, the recommendations that we are submitting are framed in the language of permanency, why it is in the child's best interest to remain in the United States. In international human rights speak, for those of you who are on the phone from abroad, what we're talking about is a durable solution, safety through a durable, permanent, or near permanent placement. On the next slide, Colleen, are some key principles from the Convention on the Rights of the Child. I will not read these, and I know these will be available afterwards, which is why I have them up on the screen. And I will readily acknowledge that the Convention remains unratified by the United States. But with respect to what I said before, a lot of the language in the Convention mirrors what appears in state child welfare law. So again, when we are asking an immigration judge or an asylum officer to consider the impact of their decision on the child's ability to remain with a parent, or whether or not we are listening to the views of the child and giving those views due weight, there is a universal acceptance of the need to do that and to consider those factors in making decisions. On the next slide, I wanted to highlight that the Committee on the Rights of the Child has issued a number of guidances interpreting and providing context to the Convention on the Rights of the Child. And I wanted to highlight two in particular, which we rely on frequently at the Young Center, and I know have been tremendously valuable to immigration attorneys representing children in asylum claims. And I would encourage you to, I think these are available, they're obviously readily available on the internet, but also can be found, I think, at the end of this in links on this program. But there's these documents are dense. They can be fun reading for lawyers like me, and I hope for some of you, but there's really valuable and persuasive language in these. So for example, guidance number 14 provides, which was issued in the year 2013. I apologize for the error in the date there, but it provides fairly lengthy explanations and examples of how each factor of a best interest analysis as laid out in the convention should be considered and interpreted. And the guidance that's in here really helps to explain how children are different from adults, and it allows both child advocates and attorneys to distinguish their clients before the decision maker. So for example, just one example listed here are the factors that are addressed in some detail in guidance number 14, but under the care, protection, and safety of the child, there are a number of recommendations, but the committee points out specifically that for children, emotional care is a basic need. And so for a child who has an appointed advocate or for a child represented by counsel where the need for emotional care factors in heavily, and I think this is relevant to the types of cases we'll talk about very shortly, there you can find a lot of valuable guidance here. On the next page, the next slide, I wanted to just reference the UNHCR bid guidelines, which has really been a seminal document for us at the Young Center. It was really developed for children in situations of displacement, but we've modified it in order to make sure that there is a principled process by which we make best interest recommendations on behalf of unaccompanied children, and that the work that we do at the Young Center is not sort of created out of whole cloth, but modeled on well-established procedures from places both within the United States and outside of the United States. And I want to note that there are so many other excellent sources of authority on considering a child's best interest that are relevant to asylum claims that we rely on and the attorneys we collaborate with rely on. I couldn't list or include all of them here, but I would highlight, for example, guidances released by Separated Children in Europe. We have also relied more recently on the Inter-American Commission on Human Rights. They released a 2016 report on the rights of unaccompanied children and families detained in the United States. On the next slide, I just wanted to give a respectable shout out to some of the work that's being done right here in the United States. For the last 3 years, or 4 years it really was, the Interagency Working Group on Unaccompanied Children here in the States, which is comprised of members of both all of the federal agencies that have responsibility for children in proceedings, as well as advocates from non-governmental organizations, met in a subcommittee to try and identify how decision makers could consider the best interests of children and what they should be thinking about when they do so. And they released a report in 2016 of last year. The link to that report is at the bottom of the slide. I think what's particularly powerful in that document is that it acknowledges that best interests can and should be considered in every decision, and it can be done in a way that does not conflict with existing immigration law. It does not say that every decision must be made in accordance with a child's best interest. It simply says that you can consider a child's best interest in making decisions about them, and that of course includes decisions as to whether or not to grant them asylum, either through affirmative or defensive proceedings. On the next slide, I'll highlight very briefly with an eye towards the time, this sort of very simple graphic, and you can all now see that I lack all skills in graphic design, but this slide shows the way we have tried to condense all of the principles on the previous pages and from domestic child welfare law and our obligations under the 2008 TVPRA to think about the best interests of the child. And we start and end with the child's wishes and the child's safety, and giving due weight to the child's wishes. I don't really think there's any age at which a child cannot communicate their wishes if they are verbal. Obviously, for pre-verbal children, that may be different, but there's certainly no bright line test. But we are thinking about what it is the child wishes for, but also their safety, and then making arguments grounded in rights to family integrity, rights to liberty, and rights to develop. On the next slide, I wanted to highlight just very briefly a case in which a child, Marlone, was successful in pursuing asylum, and in which the child advocate was able to offer a best interest recommendation that I think was particularly helpful to the child and therefore, of course, to his attorney. Marlon was a boy who was in his very early teens from Mexico. He was conscripted and forced to work for the Gulf Cartel, including work as a foot guide, which is how he was apprehended. After he was apprehended, he was placed in a residential treatment facility, which is for children with pretty significant mental health or behavioral needs, or at least that's what it should be for. In this case, Marlon's behavioral concerns were very much manifestations of unaddressed trauma. The child advocate from the Young Center was appointed and met with him for months every week and had a real opportunity in that capacity to observe Marlon over time, from his time early in custody, during treatment, and then after the treatment he received at the RTC. In that capacity, we were also able to gather vital information from the custodial agency ORR regarding his progress in care, including changing behaviors with other youth and staff. And to that end, we were able to submit a best interest recommendation to the asylum office, both of the hearings that he was required to attend, which we accompanied him to, and then ultimately submitted our best interest recommendation when his case was referred to immigration court. And as our advocate said, she thought the biggest contribution of the best interest recommendation was our ability to address who and how Marlon, who he is today and how he became the child he is today. So it was less historical in nature, which is clearly what the attorney was addressing, but much more about the changed child that Marlon really was. We were also able to answer a lot of the immigration judge's questions about placements that would be available to him before and after a grant of asylum that would help put his case in context and reassure the judge about supports that would exist for him. And quite happily in that case, he was ultimately granted asylum. The next slide just highlights a process that we use at the Young Center called bid panels, which again is modeled on the UNHCR bid guidelines. It is a much more formal process that we use in very difficult cases where we convene an independent panel of experts to review a case. We do that in those cases where we either have some kind of disagreement about the case or where we may be making a recommendation that conflicts with the child's expressed interests, where we want to make sure we are avoiding as much subjectivity as possible, reliance on stereotypes, and being rigorous in our analysis of the factors in the case. And the work of the bid panel is included in our recommendations. And I'll end in this last minute on the last slide, Colleen, just with the fact that to sort of reassure those of you who may encounter best interest recommendations, we have now been submitting these for over a dozen years to immigration courts and asylum offices. There are courts that are very familiar with our work, those that are just beginning to see best interest recommendations. The headquarters at USCIS are very familiar with our recommendations, more or less so at different offices, depending on whether we have an office in that jurisdiction. But generally, the approach we've heard from immigration judges and asylum officers is, look, we'll decide how much weight to give any particular information, but we would rather have more information than less. At the Young Center, we are very careful about the information we disclose in our best interest recommendations. As I said, many of us are or were immigration attorneys. We understand how important it is to be careful with the record and to not undermine the child's credibility. So we are very careful with the facts, but we are trying to analyze the same facts through the lens of best interest to help the judges and the decision makers understand the need for permanency. And in general, there has been a lot of support for reviewing and considering those best interest recommendations. So I will end at the next slide. I need to be careful about what services or how much availability I suggest that we have. We currently have programs just in the 8 locations listed here, and I do not expect that certainly now to grow in any particular way. But to the extent that you are working on cases in these jurisdictions and think you have a particularly challenging case which could benefit from a child advocate, we do have the capacity to assign both in cases of children who are in ORR custody, which is the majority of our cases, but also in a small number of cases where children have been released. And I have provided contact information for my colleagues who have very graciously allowed me to post their emails here. And I will stop there. Thanks, Nicole and Colleen.
Thanks, Jennifer, for that great overview of child advocacy and best interest determinations. I'm now going to turn it over to Wendy to talk about representing children from Central America in gang-based asylum claims.
Thank you, Colleen. I'm Wendy Weiligala from Kids in Need of Defense. I'm really happy to be a part of this discussion, so thank you to UNHCR and to the Young Center and all of you who are working to represent immigrant children, including asylum seekers. I've been asked to outline some approaches to establishing asylum eligibility under U.S. law, and we're focusing particularly on gang-related cases. And as a quick introduction to Kids in Need of Defense, KIND has 10 offices around the U.S. where we serve unaccompanied children through direct representation and in partnership with pro bono providers. If you are looking for more information, please visit our website. It's supportkind.org. And you can access some different resources, and if there's a KIND office near where you work, and if you want to find out about getting involved, please do contact them. We would love to hear from you. And today's topic is indeed very multifaceted, so we'll focus on a handful of facets that I think will have the most practical use for you in advocating for child clients in gang claims in particular. To start with, a few resources that are particular to children's claims are listed here, and these three are persuasive rather than binding authorities. Of course, you will also use case law, statutory law, and regulations, but we highlight these persuasive authorities for a few reasons. The Asylum Officer Basic Training course, of course, has multiple modules on different aspects of the asylum standard, in addition to the module on children's claims. But the AOBTC, we'll use that acronym a lot, is a rich source of insight into how claims are evaluated and the strengths and the flaws that may appear in a claim. So even though you won't always be before an asylum office, you may want to refer to this resource. And also in the AOBTC, as well as in the 1998 guidelines that were promulgated by the predecessor to DHS, the INS, you will find some of those same principles that Colleen outlined for us from the UNHCR guidelines, principles that apply in children's claims, and you should use them to your advantage. For example, remind the adjudicator that harm which might not be thought of as persecution if it was experienced by an adult may nonetheless be persecution when it's experienced by a child, just to take one example. And of course, you will also develop creative arguments of your own in the course of your advocacy. And the statutory definition of a refugee or an asylee is dense with multiple aspects. So it can be useful to visualize how the key elements fit together in order for an applicant to carry their burden of proof. Just for example, only one protected ground needs to be identified, but in some cases more than one protected ground could be present, and you may argue more than one protected ground. So the first element that we'll take a look at is persecution. And since today's focus is on claims arising from gang activity, part of the applicant's burden will be to show that the gang or the gang members are an organization or persons that the government is unable or unwilling to control. The roles of the gang and its members in the community and how the gang relates to government authorities may help you to show this. For example, in a country or under a government that is failing, or at least some of its institutions or functions are weak or failing, there may be evidence that the government is not successful in controlling criminal activity by gangs, or not successful in protecting the community. Even if a country has laws on the books that are designed to control gang crime. If enforcement efforts are not robust for whatever reason, it can be said that the government may be unable or unwilling to control the gang. So to analyze the element of past persecution, gangs inflict a variety of harms on their victims. At other prongs of the test, we'll consider whether there's nexus of that harm to a protected ground, but I would suggest as a starting point the inquiry into whether the harm experienced by the child constitutes persecution. And this can be pretty clear in cases of severe physical harm. That may not be where your big challenge as an advocate lies in some cases, where there have been beatings or shootings or sexual assault of your client. But let's spend some time on cases where the applicant is not reporting direct physical harm. One relevant inquiry is harm to family members. It's relevant in a child's case. As a good case to read on that point is the Hernandez case from the Ninth Circuit. And this is a case of two brothers who were ages 9 and 7 at the time when soldiers beat and killed members of their nuclear family. And the claim was actually heard about 20 years later. But the court found that it was required to consider harm to the parents and the family members that had occurred when the applicants were children. And this was not actually a gang case. The perpetrators of the harm were soldiers, but this is a good reminder, I think, to look outside the world of gang cases in your research. You will find many useful principles that can apply by analogy, and you may also at times look outside your jurisdiction. Of course, if there is binding authority on point in your jurisdiction, you will of course be bound by it, but when the circuit that you're within does not have law directly on point, you may be looking to other jurisdictions. And as we noted in the schematic diagram, past persecution is one way to begin establishing eligibility for asylum. It gives rise to a presumption that there's a well-founded fear. One way to rebut that, one way that the government could rebut that presumption is if they show that internal relocation would be safe. But in the case of children, we are told in the AOBTC, among other places, that it's generally not reasonable to expect a child to internally relocate. But if there's a period of time in the case history of your client where the client did relocate to try to avoid the harm, you should be prepared to explain why that was not a durable solution to keep the child safe. And children sometimes characterize the harm that they experienced as being harassed or being bothered. They may use the Spanish word molestar. And under the case law, we know that there must be more than mere harassment to support a finding of persecution. One pointer for approaching this question is maybe take a step back. Even if your client is using a word like molestar or to bother, consider, is that the best label? For example, when we're analyzing the Koliowski case cited here, this was a case involving a child of Russian Jewish descent, and he was maltreated by schoolmates. And some of this conduct, perhaps stealing toys, could be fairly characterized as harassment. But some of this conduct is much graver, the broken arm and the attack by the dog and so forth. So is there a word that is more apt than harassment? You might consider in your case a different descriptor, or perhaps elaborating the conduct itself rather than attaching labels to it. And finally, as the Koliowski case teaches us, look at the cumulative effect and look at the applicant's age at the time of those events. And that's what you must tell the court that they are, or the adjudicator, that they're required to do. Threats are a common experience of many children who have had encounters with gangs, threats of death, or other types of harm to the child or the child's family. It's an important element in analyzing persecution or a well-founded fear of persecution. Under the case law, and I've drawn 3 cases from the Ninth Circuit, but you may find such law in other circuits as well. Threats may constitute past persecution if those threats are so menacing that they actually cause psychological suffering. However, that's not the only route to success. Threats may also help establish a well-founded fear of persecution. As one example, a case of a woman who was threatened and harassed, never actually physically touched, but she was found to have a well-founded fear. And with that framework in mind, here's a few ways to approach analyzing threats experienced by a child. And these factors are actually drawn from the AOBTC. So if the threat is serious and the person making the threat has the capacity to act on it, in addition to psychological harm, were there attempts to make good on the threat or to cause other harms, either to the child or to the child's family? And does the child know of other persons who receive similar threats? What happened to them? And in the categories of other harms that might have been inflicted by the persecutor, you may uncover harms like stalking or surveillance or someone lying in wait for the child. And before we move on to other elements of asylum, just a quick look at some other forms of harm. Children may report harms that are a little bit outside the box, other than the harms that immediately come to mind. Being exposed to and in proximity to violence or criminal activity or gang activity can entail harm to the child and to the child's family in several ways. In a case where you may think that the facts of the case do not rise to the level of persecution, or if you believe that there was persecution but you realize that the adjudicator is not guaranteed to agree with your conclusion, you may also want to demonstrate that your client has a well-founded fear of being persecuted if returned. And the test for a well-founded fear has both a subjective and an objective element. The subjective element will involve the client's credible testimony, and it must be shown that the fear of persecution was a primary motivation in seeking asylum. It doesn't have to be the only motivation. So the person seeking asylum could also have in their mind that they hope to have more freedom or that there will be other advantages to them, but they must have a primary motive of escaping the harm that they fear. And on the objective side of the test, the test is that of that a reasonable person similarly situated would fear persecution. The test has sometimes been framed as showing the persecutor is aware of and capable of and inclined to overcome a characteristic that the applicant has. You can see that discussed in the AOBTC. Pattern and practice arguments can be used specifically to show that in the country of origin there's a pattern and practice of persecution against persons similarly situated to the client. And one of the tools for making this showing could be your country conditions evidence. At an asylum interview or in a merits hearing, some questions that are commonly asked of children are, or of any applicant really, what was the first incident of harm that you experienced? What was the last incident of harm that you experienced? And if there is a lapse of time between that harm and when the client left the country, a follow-up question may be, why did you leave when you did and not at some other time? So because there's potential for a lapse in time before departing to detract from establishing a well-founded fear, you will want to have your client ready to explain reasons for that gap. Sometimes it's because funds were not available to make the journey, or there may have been considerations of safety of other persons who were involved, or simply a hope that the situation would go away. And that may help to explain that a gap of time. So any of the 5 protected grounds can be relevant in a gang-related case, but today we won't focus on race or religion or nationality, even though those can be relevant. We're going to use the time for particular social group and first political opinion. So children can be active in political life in the traditional sense of organized political activity, but political opinion is not limited to that context only. A child who is resisting gang influence or denouncing gang activity might be doing so out of a very deeply held conviction. You can consider that a gang may be assuming a sort of political function or a de facto authority if the gang espouses explicitly or implicitly a sort of ideology, or if they are controlling their territory and who accesses it, if the gang is collecting protection money or extortion from the community, the gang may be a sort of authority entity. And a child who is opposed to that activity could be holding a political opinion, even if they don't articulate it as such. Also, remember to look for an opinion being imputed to that child by the persecutor, perhaps by the child's association with family members or other people in the community who have expressed such an opinion. Some tools that you may want to use for analyzing in the context of political opinion could be to draw out facts of the case about statements that the child may have made, not just to the gang, also to members of the community. If a child reports gang crime to the police, that could be out of a belief that a belief in the rule of law. And some children resist gang overtures or refuse demands by the gang because they are deeply anti-corruption. They may favor government or the rule of law and be anti-violence. A girl may be expressing a belief in women's rights if she is resisting sexual overtures or demands by gang members. Children could also exercise these opinions through involvement in a community group or a church group. And the second protected ground we'll take a quick look at is a particular social group. And this is a definition that has evolved in recent years. The definition of particular social group has been elaborated through a whole series of BIA decisions, and the elements of the elements to establish a particular social group or a PSG include the members must have a common immutable characteristic, a characteristic that either they cannot change or it would be unfair to require them to change it because it's so intrinsic to their identity. The group must have particularity and social distinction. A recent pronouncement on this test, and an important one, came from the Ninth Circuit, which in November held that these two elements of the definition, particularity and social distinction, which had been surrounded by some controversy in recent years, these elements are reasonable requirements for establishing the existence of a particular social group. So we'll take a look at PSGs in some examples in a moment, but to sketch out the path or the burden that the client is going to carry, first they have to identify a cognizable PSG, that is one that meets all of these tests, and they need to show that the applicant is a member of that PSG. A couple of PSGs that have been held to be cognizable are drawn here from the case law, and these include witnesses against gangs in the criminal context. Also, nuclear family as a PSG can be relevant in the gang context if a family member is being targeted for persecution because of their family relationship to a person targeted by the gang. And a couple of PSGs that have been proposed and rejected in the case law. It's good to, these are instructive. It's good to know where it stands so that you can factually distinguish your case or reframe and reformulate according with these principles. And in the interest of time, I won't read all the way through them. I'll just pose a quick question. What about, as a particular social group, girls who have been sexually assaulted by gang members? That sounds fairly particular. It's not obvious if it's going to pass the social distinction test, but the other important flaw is that the argument is circular. We've identified the persecution that was visited on the person as the immutable characteristic of the group. And finally, nexus to a protected ground can be one of the challenging elements of building your case. Nexus means that the applicant's possession of one of the protected grounds must be one central reason for the persecution. And even if there is a protected ground established, if some other motivation is primary, like the persecutor simply wanted to rob the person for economic gain or extort the person for economic gain, or if they attacked them physically for revenge that was purely personal, that may not pass muster for nexus purposes. It is, however, acceptable if there is a mixed motive, and very often the persecutor may have mixed motives. It's hard to know exactly. The Singh case is instructive. This is a case where nexus was established because of the words the persecutor used while delivering a beating to the victim. Beware, though, that coincidence is not going to carry the burden for nexus. If someone is beaten in a church or near a church, that doesn't automatically mean that they were being persecuted on account of their religion. And with that, I will deliver back to Colleen to take us through our case example.
Thanks, Wendy, and thanks for going through that detailed run-through of the elements of the asylum claim, in particular to children's cases. So we're now going to go through a case example. I put together some facts here. I'll read the facts, and then afterwards we can go through how to approach the claim and what international guidance is relevant. So the facts are: Calvin, age 16, is from Honduras. He entered the U.S. as an unaccompanied child at age 11. Growing up in Honduras, Calvin was targeted by gang members from a neighboring town. The gang members beat him, attempted to rape him, harassed him, and on one occasion left him tangled in a barbed wire fence. Calvin believes that all of these incidents were motivated by the gang members wanting to recruit him into their gang. At age 13, Calvin was interviewed by the asylum office, which referred his case to the immigration court, which heard his case last year. The immigration judge found Calvin was credible and had a subjective fear of return to Honduras. However, the immigration judge found that Calvin had not established past persecution and that the harm was not on account of an anti-gang political opinion nor on other statutory grounds. The case is now on appeal to the BIA. I'm going to give it back to Wendy to first talk about the elements that must be proven in the asylum case and how an attorney should go about preparing those.
Okay, thanks, Colleen. First important threshold issue we have to look at in this case study example, the posture we're in is Calvin is appealing. So that really forces us as advocates to focus on making legal arguments to the board based on the record that's in front of the board. For discussion purposes, we could also consider what factual development could have made a case like Calvin's stronger. But to analyze the particular problem that you've put before us, we have to look at the legal issues within the record on Calvin's appeal. So we know that the IJ had found there was no past persecution. We may, as advocates, disagree with that conclusion. So we can present those arguments, or we can also argue that there was a well-founded fear of persecution, assuming that that argument was preserved in the record. And we were also told that the immigration judge did not find that did not conclude that Calvin was persecuted on account of a political opinion. So we may contend that the IJ was wrong and that either political opinion or other protected grounds are established in the record, and that there's a nexus to those protected grounds. Finally, the last couple of points here, the bars to asylum and favorable discretion, as well as related forms of relief, humanitarian asylum, withholding CAT. That's beyond the scope of our case study, but we're just flagging them for you as they can be important in your analysis and building an argument. Should we go to the next slide, Colleen? Okay, so I can suggest a few factors that you may want to use in approaching the briefing in Calvin's case. So the first finding that we need to deal with is that both the asylum office and the immigration judge concluded that persecution was not established on these facts. Because some of the harm that is described in the fact pattern was pretty severe, I wonder whether the immigration judge really was concluding that this harm was not severe enough. For example, an attempted rape and being left tangled in a barbed wire fence. It's fairly severe, and was the judge really finding that's not severe enough to constitute persecution? If so, in case that is the case, we may want to remind the BIA that both the INS guidelines and the UNHCR guidelines and case law direct us to consider that harm from the point of view of a child, even if it wouldn't have been persecution if Calvin were an adult, it should be found to be persecution given his age at the time. Another aspect that may have led to the denial on this basis could be that the immigration judge did not think this harm was inflicted by actors that the government was unable or unwilling to control. So that's going to be an important area to follow up on appeal. And separately, or alternatively, if a well-founded fear was argued below, we would definitely pursue those arguments on appeal, because if a well-founded fear is established, it won't matter if the BIA disagrees that the conduct that Calvin experienced constitutes persecution. And the second question was nexus to a protected ground. Well, to start off, what protected grounds apply? The immigration judge referred specifically to not finding political opinion. So we may want to bring out facts that were in the record that do tend to show that, in fact, Calvin held a political opinion in opposition to the gang, and that the gang sought to punish him on account of that political opinion, that was their primary motivation. There may be other protected grounds that were identified in the record below, so of course those would be appropriate to pursue as well, even though we can't make a brand new argument for the first time on appeal. And then finally, the child-sensitive approach. Are there things that were error below that the immigration judge should have done differently? Was there questioning or an interpretation of the answers given to a question that wasn't appropriate because of failing to take into account the applicant's age and capacity at the time that he was testifying, as well as at the time that he was experiencing harm. And those are the three biggest factors that I want to see for starters. But if others, Nicole, Jennifer, Colleen, if you want to bring in new dimensions, please do.
Thank you, Wendy. I just want to talk briefly about what international UNHCR guidance is relevant, specific to the two issues that were pulled out, and the two issues being past persecution and nexus. So I've listed here a few resources that could be used to strengthen arguments under both of those factors. as Wendy already talked about in regards to past persecution, the guidelines on child asylum claims could be used to strengthen the argument that the claim needs to be evaluated from the child's perspective, so taking into account that these harms happened when Kelvin was 11 years old, and so from how his point of view at that age, the harms that were inflicted could rise to the level of persecution. Also using the guidelines on child asylum claims to encourage the judge to look at all evidence in the record, so any affidavits from relatives or parents that may be able to provide a fuller perspective of the child's claim. And on the nexus point, the other three resources, the UNHCR Gang Guidance Note, Children on the Run, and the Eligibility Guidelines for Honduras, these all help to make sense of the harm inflicted by gangs. The Gang Guidance Note goes through the legal analysis of the refugee definition, going through each of the factors, persecution that's often inflicted by gangs, and then running through the grounds to protection, race, nationality, political opinion, particular social group, and religion, and how each of those may apply in a gang case, with some discussion of children's cases. And then Children on the Run, which we've already talked about, could be used as evidence of surrounding circumstances, so to help explain how these harms that happened to Kelvin are part of a broader context of the situation in Honduras, and looking at reasons why children are fleeing more generally, as well as the types of harms that he may have a fear of in the future. And lastly, the eligibility guidelines for Honduras. I think that these are really relevant. The guidelines actually discuss children and youth with certain profiles or in specific circumstances as one category of individuals who may be in need of international protection. They discuss harms that children in Honduras may suffer, including gang recruitment and risks associated with refusal to join a gang. The guidelines take the position that children in Honduras, and particularly children from areas where gangs operate, may be in need of refugee protection on the basis of membership in a particular social group or political opinion. So those could be used to support the view that under international law, we have taken the position that someone in Kelvin's circumstances could be in need of international protection. And I don't know if anyone else has anything to add to it. We're going to have some time for questions at the end, but otherwise, Wendy, Jennifer, feel free to chime in with anything that I might have missed.
I think that was really helpful. Thank you.
Okay, so you should be able to ask questions in the chat box, and we've already got a few. The first couple were about whether the presentation was going to be available, so I just want to say again that the PowerPoint slides and a recording of the webinar, we'll make sure to circulate those after the presentation. So I have one question. Has anyone used international convention guidelines to argue for predicate orders on SIJS cases?
Wendy, can you speak to that?
I can't say that I have done that. I'm mindful that in the context of the SIJ predicate order in state juvenile court, state law applies, and it can sometimes be a sort of a dislocation to the state judge when asked to go beyond their usual purview, and when sources are unfamiliar. It could be persuasive in some cases. I haven't used it, but I think it's a creative idea if you especially if you have some intelligence about your some intel, I guess, about your bench, and you know that they're receptive to arguments about international protection or international human rights.
This is Jennifer. I would just add that I would echo what Wendy said in terms of state law and what I had said earlier about sort of there's tremendous consistency between some of the international principles and state law, and being able to sort of pull out those elements of state law that resonate and I think is really the best place, at least in our experience, that the judges want to be referred to sources of authority with which they are familiar and they believe to govern their proceedings. But to the extent that any of the resources identified today can provide some context, and it's always important to be careful about not overgeneralizing such that the state court judges believe that every child from a particular country is going to be making the same kind of claim. But to the extent some of the details in these reports and in related reports can provide some context, they may be helpful in demonstrating why the principles of state law, in fact, open the door to the kind of predicate order that you're seeking.
This is Wendy, and I want to pile on with one more idea, and it's that especially recently, we've, I think, heard increasing attention from USCIS to their view that and the requirement that the findings in the predicate order be made under state law. So even if sources from the international law realm are persuasive, you need to be certain for the record that the judge is, in fact, making their findings under state law, because that is what USCIS will require.
Okay, great. Yeah, I think that answers a lot of the question. We have several more questions, so I want to move on to the next one. The next one is asking about, what about a political opinion about children's rights? Is having a belief in children's rights a political opinion? I'm sure, Wendy, you have other thoughts on this, but just to mention that from the international perspective, I believe that it would be, under international law, manifestation of a political opinion could be in regards to human rights, so a belief in the rights of the child. I think that could constitute a political opinion. You could pull from the Convention on the Rights of the Child to, even though the U.S. isn't a signatory, to get an idea of what those rights might be, but also just keeping in mind that the harm inflicted would have to be on account of the children's beliefs and their rights. I don't know if, Wendy, you have any other thoughts about how a political opinion could be on the basis of children's rights.
Maybe just to add that you will want to draw on facts that tend to support that the applicant in fact sincerely held such a belief and that they've manifested that belief. You may also want to tie it to some of the particular social group case law on persons treated as property within a relationship. So the child may, that concept may be antithetical to the child's opinion, and they may believe in the autonomy and integrity of the child as an individual.
Okay, great. The next question is, might an immigration judge viably challenge a minor's imputed political belief due to a child's lack of maturity to develop such beliefs? They're thinking of female victims of domestic violence or gang violence and who reports the attacks. I think that really implicates viewing the refugee definition through a child-sensitive manner. So I think in the guidelines on child asylum claims, they do go into a little bit of discussion about political belief in children's cases, including this question that's been asked about what about the child's lack of maturity and their ability to kind of comprehend and understand what's going on. So I would point you to those resources. Wendy, again, if you have anything to add.
I guess just a sense that I agree it is a challenge depending on the maturity level, not just the chronological age of the child, but you would need to develop facts that tend to show that they hold this belief, even if they don't label it as a political opinion, and that they've been consistent in holding it, or that it is developed in the child and been manifested. So I agree it's a challenge, but I think that it's not an impossible challenge.
Great. The next question is about the particularity requirement in the particular social group analysis. They ask how we recommend framing the resources in a way that doesn't cut against the particularity requirement. So again, assuming that the IJ might think that the claim is too broad, how can we use these resources to rebut that analysis? I think this is a good time to note that under UNHCR's view, particular social group is an either-or analysis. So in U.S. domestic law right now, most courts require particularity and social distinction, but it's UNHCR's view that either particularity or social distinction, but not both, should be required. So in cases where you're preparing a claim, could submit UNHCR's views to say that both shouldn't be required, but Wendy probably has a little bit more experience in confronting that challenge.
Yeah, it is a challenge. You want, if the group is naturally susceptible of being defined by some limiting factor that's appropriate, there may be a dimension that you need to add, like the location or the nationality, or a characteristic like children who live or attend school in a region that is contested by two rival gangs. There may be characteristics that naturally serve to limit the group. When you have a very broad group, like children from El Salvador, then yeah, you are certainly at risk of it being not particular enough.
Okay, great. So I think we have 2 more questions, but feel free to keep asking. The next one is, would it be advisable to separate children's asylum claims from a parent's claim when the persecution was perpetrated specifically to the child and then eventually involving the entire family? So I might defer to Nicole and Wendy, but I would just say that it obviously depends a lot on the facts of the case, whether that would be an appropriate measure to take.
Well, from UNHCR standpoint, our guidelines strongly state that a child, no matter how young, has the right to be the principal asylum seeker, if that's appropriate for, relevant to the child's the success of their claim. In terms of actually how this plays out, in terms of considering the strategy, Wendy, do you have anything to add?
So many variables could affect whether which choice is better in a particular case, and you also have to ask whether it's a better choice for a child or for other members of that family, and you need to look at whether those interests could not be fully aligned. So you may also have to look at it from the standpoint of a conflicts of interest and make sure that no one's interests are being prejudiced by how who is representing each person and how the claim is presented. But that's I guess a question that's for another day. But yeah, I think that it could go either way, really depending on the factual situation and the environment.
Okay. All right, so the last question is somewhat related. They ask how these principles and standards apply to children who are not accompanied but are derivatives on a parent's asylum application. So I just want to point out that the guidelines on child asylum claims and the resources that I've cited are applicable to both unaccompanied and accompanied children, so both can be used in these claims.
Right, just but particular attention to the added vulnerability of unaccompanied children. But yes, guidelines are applicable to all children from UNHCR's point of view. Let's see, any other questions coming on the horizon?
Jennifer, I don't know if you want to add anything, any of the questions that have been posed, any areas you see where a child advocate or best interest determination would especially play in.
So again, thanks, Colleen, and I think what comes to mind are by no means are child advocates in a position to evaluate a child's capacity to make certain decisions. But to the extent there are concerns about a child's capacity where it may be helpful, either, especially if the child is in custody, to have somebody weighing in on whether it's in the child's best interest to have an evaluation done. Those might be cases that could be referred to us. In a lot of cases where a child has counsel, they're in very good hands, and they have an advocate who is looking out for their expressed interests. But the cases that come to mind where a child is represented by counsel and yet advocates have been able to make arguments advancing the child's best interests often involve those where there are concerns about the child's ability to guide counsel's to guide counsel, or if there are cases in which you've been working with a child who is in custody and who is detained and who has submitted a claim for asylum, who has strong facts, and who, for reasons that may be due to where they are in their appropriate developmental stage or the conditions of detention, suddenly express an interest in abandoning the claim, which is most certainly their prerogative to do. But we've been involved in cases, for example, where a child marched into court and said, "Your Honor, I'd rather die a quick death in my home country than have to spend 3 more months not knowing what's going to happen to my case here." And a case like that can put an attorney for a child in a real bind. In those cases where a child advocate has already been appointed or can be appointed, we may be in a position to make arguments about the child's placement and custody conditions so the child can get to a place where they can reconsider their decision and determine whether or not that's the course of action that they want to take. So by no means do I want to overpromise either our capacity or our influence in particular cases, but the ones that come to mind, and especially in light of the questions that have been asked and the kinds of cases we've been discussing today, and for those of you who are doing the extraordinary work of representing these youth, those may be the kinds of cases where it would be appropriate to think about making a referral for the appointment of a child advocate. And anyone involved in a child's case in any way, including the child's attorney, can refer a child for the appointment of an advocate. Whether we're able to do so is generally a matter of capacity.
Great, thank you, Jennifer. So if there are no more questions, I just want to end thanking all of our speakers, thanking Nicole, Jennifer, and Wendy for giving such great presentations, and thank you to all of you for participating.
Have a good afternoon, everyone.
Thank you, everyone, for your great work.